USCIS chose a holiday weekend to make one of the biggest changes to adjustment of status policy in the US. Okay, this is a huge change, and they're choosing when we're supposed to be, relaxing and not thinking about work to put this out. So guess what? Now I have to make a video updating you on what these changes are and making sure that you understand what you can do if you are planning on applying for adjustment of status to make sure that you still can get your case approved. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. On May 21st, 2026, USCIS updated their policy memo to make adjustment of status under the INA 245 as an extraordinary discretionary relief. What does that even mean? It means that it is an act of administrative grace and not a right. So typically when you think of adjustment of status, if you meet all the requirements, you're able to apply and USCIS approves it unless you have negative factors that they can use to stop the application. So for example, criminal history, negative immigration history, your marriage not being real. Those are negative factors that they can use to deny your application on discretion. Now, USCIS is saying adjustment of status itself is a negative discretionary factor that an officer needs to look to when they are making a decision on whether to approve your green card application or not. So adjustment of status, for those that do not know, is when you are applying for a green card in the United States, not outside. So if you're applying for a green card at a U.S. embassy, you are not applying for adjustment of status. If you are in the US, let's say you are on a B1, B2 visa, you overstayed that visa, you get married to a US citizen, and you are adjusting your status to that of a green card holder, you are affected by this new policy. The fact that you do not have a criminal history, the fact that your marriage is real, the fact that you meet all the requirements for adjustment of status is no longer enough under this new policy for you to get your adjustment of status approved. That's the key here. Just meeting the requirements for adjustment of status is no longer enough if you are applying for adjustment of status. Basically, USCIS will see you adjusting your status in the US as a negative factor if there is the chance for you to consular process, meaning go to a USCIS embassy and apply for a green card through that embassy, get your immigrant visa, come in and be a permanent resident. So if there is consular processing available, USCIS is allowed now to look at you adjusting your status in the US as a negative factor affecting discretion. Adjustment of status is one of those things that is predicated on discretion. So even when you meet the requirements, it is still up to the officer's discretion whether to approve your case or not. And typically, before this policy, that discretion is based on negative factors like criminal history, immigration history, things like that. Now, you adjusting your status when you could potentially consular process is now part of that negative factors that the officer needs to take into consideration when doing their discretion review. According to this new memo, the officer has to look at different factors in order to then make a decision about discretion and whether to approve the adjustment of status. The factors the officer has to take into consideration when making this discretionary decision are: officers must consider your immigration law violations, status compliance history, conduct inconsistent with non-immigrant admission purposes, and any intent to circumvent the ordinary consular immigrant visa process. So what does all of this mean? So one, if you violate any immigration laws, if you overstay your visa, that is now a negative factor that the officer needs to consider. If you did not comply with your status, let's say you came in on an F1 visa and you worked during that process, that is now a negative factor. Conduct inconsistent with non-immigrant admission purposes, meaning if you came in on an F1 visa intending to go to school, but you never actually attended the school, that is now a negative factor. And any intent to circumvent the ordinary consular immigrant visa processing. This part is when you enter the US with the purpose of adjusting your status and not to actually visit. So if you and your spouse have a discussion and you have decided, okay, instead of consular processing, which means we're going to be apart and we may, it may take years for this visa to work, let me get a visiting visa to the US, come in, and then apply for adjustment of status because that will be faster and we'll be together. That is circumventing the ordinary consular processing process. One thing to note here is if an officer is going to deny your application based on this new discretion policy, they need to write a detailed statement about why they are denying it, identifying all the negative factors that they considered and all the positive factors that they considered when making that decision. Now, when does this policy apply? I said adjustment of status, but there's one caveat to it. Adjustment of status where consular processing is available. Okay, that's really the key here. Is consular processing immediately available or reasonably available to that person and they're choosing to adjust their status? That's where this will really kick in hypergear, if that becomes the case. So the group of people that fit squarely within this new policy are immediate relatives of US citizens. So children under the age of 21 and are married, parents of US citizens, and spouses of US citizens. It's really important to note that this does not have any exceptions or exemptions for immediate relatives of US citizens, including spouses of US citizens. Now let's talk about the impact that this is going to have on adjustment of status for spouses and other immediate relatives of US citizens. It's important to note that this memo specifically does not talk about the requirements of adjustment of status. It is only talking about the discretion part that the officer has to put into every single application. So you can meet all the requirements for adjustment of status, but the officer can still deny it based on discretion using this memo. The INA, Immigration and Nationality Act, under Section 245C has a carve out for immediate relatives of US citizens, where they say if you worked without authorization, it's waived automatically. If you entered the US with a visa and overstayed that visa, your overstay is automatically waived as well. That is a requirement, right? So those requirements are now waived. However, on the discretionary side, according to this memo, USCIS can use that overstay against you. USCIS can use that working without authorization against you when making a decision on discretion. If you're starting your adjustment of status process, what does this mean for you moving forward? What do you need to keep in mind as you make the decision to consular process or adjust your status? Know that this memo is not going away. It is already being applied at interviews that happen after May 21st. If you have not filed your adjustment of status application and you're listening to this and wondering, what do you need to do next? Should you even file? You need to consult an immigration lawyer, because this is no longer a game where you can DIY your way through it. USCIS is taking this very seriously. They are already applying it to interviews that happen on Friday. Okay, this memo came out on Thursday. They are applying it to interviews that happened on Friday. So I want you to be very clear that this is not something that's just going to go away. They are already applying it. So you want to make sure, if you already have a case pending or you're just starting your green card journey, that you are talking to an immigration lawyer before you take any steps. If you would like to get a private consultation with me to see what you need to know, what you need to do to make sure that you are protecting yourself and your family through this crazy immigration policy, please feel free to schedule a strategy session with me. You can do that by going to my website, lilylegal.com/contact us, where we can set up a time for us to talk about your situation and figure out the best way for you to handle your adjustment of status application moving forward. When you are applying for adjustment of status, you usually include the documentation that are required, like the I-485, the I-864, the affidavit of support with the supporting documents. If you want to apply for a work permit, you're including that application. Now, a new thing that this policy memo is going to require you to include is a statement, okay? You want to include a statement that goes to the discretion. You want to highlight all the positive factors that apply to your situation. This is no longer just meeting the requirements of adjustment of status. You also want to address the discretion part, because the officer now has to make a decision on discretion. So you want to make sure that you are including a statement on all the positive factors and addressing any negative factors as well, to make sure that you are giving the officer full picture of your situation and giving them a chance to actually see that they should give you a positive discretion and approve your adjustment of status. Now, that affirmative discretion statement needs to include certain things. So you want to address why you are adjusting your status instead of consular processing. You want to address that, because that is going to be a factor that the officer needs to consider moving forward. Secondly, you need to talk about any hardships that can result from separation. This section is going to be similar to if you're applying for a 601 waiver or 601A waiver based on extreme hardship to a family member. So you want to focus on, your length of presence in the U.S., children in the U.S., employment, medical, all the factors that will cause hardship if you were not allowed to remain in the U.S. Then you want to talk about your positive equities, the good things you're doing in your community, your family ties, your employment history, the fact that you're paying taxes in the U.S., if you are married, how long you've been married, right? If all your family is in the U.S., that's a positive factor, right? So those are things you want to talk about. Then you want to talk about your immigration compliance history. Again, that's if you have complied with your immigration requirements. So if you entered on an F1 and you did maintain your F1 status, you did go to school, you did not work without authorization, you just happen to have gotten married and now want to apply for adjustment of status in the US so that you, one, are not missing school, and two, are not missing your spouse. That is a positive immigration compliance factor. Okay, so you want to include that as well. Now, if you have a negative compliance factor, you want to address why you did not leave the US when your visa status ended, why you chose to stay in the US and overstay your visa. Those are things that you want to consider putting in that statement, because again, it's a negative factor that the officer is going to consider, and they're not going to have your statement to go along with it unless you address it. So you want to make sure you're putting that in the statement, because again, you want to explain any periods of time that you did not have lawful status in the US or that you violated an immigration law. And then you want to do a statement of why your positive factors outweigh the negative factors. Again, this is something that your attorney should be working with you on. This is not something you should be doing on your own, right? I typically moving forward, will have my clients write their initial first statement answering these questions, and then we're going to work together to actually put it in a form that the officer is going to like, right? So making sure that it is clear, concise. You're not writing like a 20-page statement here. You want to be direct to the point and clear as well. But you want to be detailed enough that the officer gets the full gist of what you're trying to say. Now, if you already have your application filed, right, that statement of discretion is really helpful. If you have not filed your adjustment of status application, you can include that with your adjustment of status application and file that with USCIS. You can also choose to do that discretion statement and upload it to your USCIS account so that the officer has that in there as well. So those are the two ways that you can actually use that discretionary statement. You can either file it with your adjustment of status application, or if you have already filed your application, include that as unsolicited evidence and upload that. Now, you should be talking to your attorney before you do any of that, because again, they should be working with you if you are going to do that statement to make sure that it is going to be a helpful statement, right? You want the statement to help your case, not hurt your case. So do not just write anything. Do not just go to ChatGPT to write it. You want to make sure that it is something that's going to help your case. Now, if you have an interview coming up, and this is something I will be doing with my clients moving forward, because again, we have interviews coming up. We're going to be doing mock interviews. That's something we do with our clients, is that before their interview, we do a mock interview, answer questions, make sure that they are prepared for the interview. Now we're going to be including this next section to that mock interview preparation, because it is now a much more intense process than it would have been before, because now there's no more clean adjustment of status application. Even if your marriage is real, the officer can still deny your case. So let's talk about what questions to expect at your interview that you need to have an answer for. Okay, you need to have an answer for these questions before your interview. The first question is, why did you apply for adjustment of status instead of consular processing? Remember here, you want to be clear and credible. Your answer has to be credible. It has to make sense to the officer why you chose adjustment of status instead of consular processing. Has to make sense. And in most situations, people choose adjustment of status because of their family unity. They want to stay with their family and not have to leave the U.S. to consular process. They want to stay with their spouse, their parent, their child. Okay. There may be hardship due to the separation. So if there's going to be hardship, if you had to consular process, that's another thing to factor in. If you have U.S. citizens, children, employment, if there's specific delays at your embassy. So for example, if your embassy is Lagos, Nigeria, and you have the option to adjust your status in the US or leave the US and consular process, 9 times out of 10, you are going to choose adjustment of status, because that consular processing wait is at least 2 to 3 years. And that's after your I-130 is already approved. That's after you are documentarily qualified. You're still waiting 2 to 3 years for an immigrant visa interview. So again, post specific. If you are, let's say, for example, in the UK or Canada, you're not waiting a year, you're not waiting a year for a consular interview. So that's going to be a less helpful answer to say that, the wait time, because the wait time in certain countries are less than other countries. Now, if your answer to why did you choose adjustment of status over consular processing is, well, it was much easier, or, oh, my lawyer suggested it, that is not a good answer, right? It doesn't go to the heart of the matter. It doesn't give the officer what they need to overcome that discretion, that negative discretion. Okay, remember, you adjusting your status instead of consular processing when consular processing is available is already considered a negative factor. You need to give the officer an answer to why did you choose adjustment of status over consular processing. You need to give them an answer that turns that negative factor into a positive factor. The next question is, are there any factors that would prevent you from pursuing consular processing, right? Are there any things that will stop you from leaving the US and adjusting your status outside of the US? You want to look at whether there are barriers that will make it hard for you to consular process. For example, if you have bars, if you have overstayed your visa for more than 6 months, you have a 3-year bar. If it's been a year or more, you have a 10-year bar. So those are factors that will come into play here. So why would you choose adjustment of status over consular processing? Well, if I consular process, I will have to leave the US. And once I leave the US, there's going to be a 3 or 10-year bar put on me. And then I won't be able to, be with my spouse. And I will need to apply for a waiver, and the waiver takes blah, blah, blah years, and I'm out of the US that whole time, right? And then and that's going to, again, affect my family unity, extreme hardship, all of that, right? There's layers to your answer, and that's why I say you need to work with your attorney to understand what these questions are really trying to get to. This is not like a conversation that's just like, oh yeah, I just thought it would be a great idea to to adjust my status instead of consular processing. No, they are looking for reasons to deny your application. Keep that in mind. Next question, do you have any family still living back at your country? Why does this question matter? Because if you're saying that you're coming to the US for a visit and then you end up staying, getting married, and adjusting your status in the US, right? But you have children, minor children not back home. You have parents, you have siblings, you have all this family back home. That means you have a lot of ties over there. That's going to lead the officer to question whether you adjusting your status in the US actually makes sense, right? This is going to come in even more for parents of US citizens. So if you're a parent of a US citizen, you came in on a B1, B2 visa, and then you decided to stay and adjust your status in the US. But back home, you have your spouse, you have your other children, you had a job that you left, you had all these other things going on, but you chose to stay in the US and adjust your status. The office is going to look at that negatively. Now, if you're a parent of a US citizen and all your children are in the US, and your spouse is in the US, and your whole family is over here, your immediate family is in the US, your grandkids are in the US, that's going to be more of a positive factor than a negative one. So it's really important to understand why they're asking these questions. Okay, I feel like when you understand why the question is being asked, it's easier for you to understand your answer, right? And be able to articulate yourself. Because one thing that I learned in law school, and that has been true in all of my years of practice, over 10 years of practice, is that you do not answer a question that you do not understand. Okay, you need to understand the question that's being asked, the words, but you also need to understand the intent behind that question. Why is this person asking me this question? Why does this question matter? Because that is going to change how you answer the question, right? If someone is asking you, how are you doing today? Right? It's different if it's like a friend saying, hey girl, how are you doing today? Versus your doctor asking you, how are you doing today? Because your doctor wants to know if you have any discomfort, if there's any medical issues that they need to know about. Your friend is just asking you, oh, how are you doing today? More of like, I'm good, everything is great, or, oh, I'm so busy, right? That's the intent behind the question is the same question, but the intent behind them are different. Those people are asking you the same question for different reasons. So when you are looking at the questions the officer is going to ask you, you need to understand the intention. And that's why I'm spending so much time on these questions and the intention behind it. What is the officer trying to get out of you for these questions? The fourth question is, why did you not return to your home country once your period of stay expired? This is really important for people that overstayed and people that came in with parole. Your parole expired, you did not leave. Your visiting visa period of stay expired, you did not leave. Your student visa, you finished your school, you did not leave. Your H-1B expired, you did not leave. Those are the things that the officer is going to be looking at here. Why did you overstay? Why did you not leave? And your answer needs to be honest, okay? But again, you need to make sure that you're doing a mock interview with your attorney because the words you use matter here. Now, if your overstay was brief, like a couple months, let's say you came in on your B1, B2, and then you were having a conversation with your spouse about whether to stay or leave, and you just eventually decided to stay, but you didn't get around to applying for adjustment of status till like a couple months later. Okay, you explain that, right? If your period of stay expired, but you did not apply for adjustment of status for like 10 years later, that means you had 10 years of overstay. That is going to be a very negative factor. So you want to make sure that you are including a lot of positive equities, rehabilitative factors like job history, paying your taxes, just like showing that you have been a good contributor to the U.S. while you have been here for that 10 years. Those are things to keep in mind. It is important to know that these 4 questions are not going to be standard on all adjustment of status interviews. Like I said, they are already asking these questions. This policy came out on May 21st, and any interview that happened after this policy came out got these questions or variations of these questions. So you need to be prepared to answer these questions, okay? Remember, the question may not be worded exactly the way I worded it, okay? It may not be worded the same way, but you need to understand that those are the type of questions that will come up, and you need to be prepared to answer those questions. Like I said, for my clients, our mock interviews are going to be very much making sure that they are prepared to answer these questions and understand the intent behind the question. Why does the officer care about any of this, right? How does your answer affect the officer's decision? So that is really important here. Finally, I will be doing you a disservice if I did not say this part, okay? If you are in the process of considering adjustment of status or consular processing, where you still have that choice. Some people do not have the choice, right? They already overstayed their visa. If they left, they would not have, they will have to apply for a waiver in order to come back, or they will have to file for a waiver before they leave. But if you still have that choice of consular processing or adjustment of status, you are still in control, right? You are still in control of your process. You can still decide to consular process and avoid this part of things, because unfortunately, people that get caught up in this discretionary factors and are not prepared for their interview, are not prepared with that statement, are not prepared with evidence of the positive equities, are going to end up having their adjustment of status denied and end up in removal proceedings. That is what's going to happen. That is not me trying to scare you. That just means being real, because again, even though this is a new memo, the NTA memo is still there. It did not go away. They did not, take that away. The NTA memo is still there, and USCIS is implementing that NTA memo. So that's why I'm telling you, if you are working with an immigration attorney, with your adjustment of status, you need to be having these conversations with them and make sure that you are prepared for your interview, and that as you're preparing your adjustment of status application, you are including that discretionary statement to help before you get into that interview, so that the officer already has an overview and can get to the questions that really matter to them in that interview. You want to give yourself the best opportunity for your case to be approved. And if your case is already filed, you want to give yourself the opportunity to be prepared for that interview and be able to answer these questions. If you are in a situation where you are trying to decide between consular processing or adjustment of status, or you already filed your adjustment of status application, but you have an interview coming up, I have so many options for you. You can schedule a detailed consultation with me to talk about your options as far as consular processing versus adjustment of status. If you already have your interview scheduled and you want a mock interview, you can actually schedule that with me as well, where I go over all the questions and pretend to be the officer and make sure that you are prepared for your interview and you understand the type of questions that will be asked. And I can give you kind of a grade based on your performance at that mock interview. And then if you would like help with your adjustment of status process, feel free to reach out as well. You can schedule a strategy session or a detailed consultation, and we can see the best way we can work together to make that possible for you. If you want to do any of these, the best way to do that is go to my website, lilylegal.com, click on contact us, and you can pick a date and time that works best for you for us to talk about your situation and figure out the best option for you moving forward.